debate over that phrase. So that's, again, and this is a guy who's running for election, consciously thinking, you would think, of putting his best face out there. So that's just one example. Another example, a kind of anomalous case, is that within the last couple of months, a rape conviction in a progressive state like California was overturned based on a law that was on the books for 150 years, which effectively said, and the facts were, that an 18-year-old woman was at her apartment, her boyfriend had been sleeping with her or lying with her, he left the bedroom, another 18-year-old male who was in the apartment came in, pretended to be, disguised his voice, pretended to be the boyfriend. She was half asleep. He got in bed with her, raped her, got a conviction, and at the Supreme Court level or the appellate court level of California, the rape conviction was reversed because of a 150-year-old law that provided that if you're unmarried and you take someone into your bed willingly, she didn't resist thinking it was her boyfriend, that you can't get a rape conviction. So those are just a couple of, again, small examples. So speaking as a lawyer, I'm just going to kind of lay out some things that I experienced in bringing sexual violence cases to trial or assisting in that. And this also goes to some extent for domestic violence cases, for sexual harassment cases. I do a lot of work with sexual harassment at home. We have the same problems, of course, in getting women to come to make out what we call the complaint, the FIR here. And all of the factors that feed into whether a woman actually comes to the police station to make out the complaint. And I can assure you, we don't have any progressive, it may only be a small sector here where someone comes to help the woman make out the complaint. We don't have anything like that I know of anywhere in the U.S. The woman has to come to the police station and make out the complaint. And whether or not she ever comes depends on all the things you've been speaking about here. What class she's from, how well educated she is, whether she's homeless, the equivalent of abandoned, whether she is intellectually or physically challenged, the support of her family, whether it's a so-called date rape where the woman presumes almost that she won't be, no matter how educated she is, she won't be believed, whether it's marital rape, which incidentally we allegedly prosecute, but in virtually every state it is more difficult and it's a lesser crime than non-marital rape. So all of those factors feed into whether the woman ever gets to make out the FIR, the complaint, to begin with. Same in the U.S. as it is here. However, when the woman comes to the police station to make out the complaint, I think the complaint process is more open and more regular. And maybe that's just time. It takes so much time to get these protocols enforced. But there's a protocol, and more or less it is followed by the police after decades of training. And not that you ever rest, you keep on training, you keep on, pointing out their mistakes, etc. And then when some advocate, it goes to the prosecutor. The state prosecutor ultimately is the one who actually has authority to bring the case. But the woman may have her own counsel, may have an advocate of some kind to support her in bringing that case forward. But when we look at the complaint, we make sure that every possible basis for the prosecution is named, so that we have a sexual assault law, we have assault and battery apart from the sexual element of it, we have a hate crimes law, so if sexual violence, the rape could be based on race, there is unfortunately a kind of groundswell of straight men raping gay women, sort of the ultimate power thing, if you think about it, wanting to show that, a woman either can't be gay or should be punished for being gay or is going to be overtaken, who knows, converted to being heterosexual. But and that would be the basis for a separate hate crime claim. So we make sure that every possible credible basis for legal action is listed on that complaint, so that we don't just stand or fall on, one piece of evidence. Again, making sure that it's a credible thing. We don't just throw everything in. So, for lawyers out there, you may be doing this. It's something that lawyers at home kind of got onto slowly, but it is a very useful thing to do, and hopefully when the rape bill passes in some form, you will have an additional tool, but don't forget about the ones you've got. When the case goes forward in the court system, the ideal, and it depends just as it does here on funding and on resources, more likely in an urban area than in a rural area, but we have a system of victim witness advocates, people who come forward and it's a service, who support the woman or a witness, because it's also very difficult to be a witness in these sexual violence cases. You get the same pressures from family, from community, from, the same fears that you have coming forward as a witness. So the victim witness advocate is with the woman and doesn't provide the same services that your excellent rape crisis prevention centers provide. It's not that full range of social services. We do have some services like that. But she really supports the woman, and generally it is a she, supports the woman in going through the case, and is also at the prosecutor's side, making sure that the case is carried forward with some energy. So I think that's a useful system. Again, it's kind of like talking about Dalit or the Northeast. I mean, there are a lot of resources in the city for these kinds of things. The further you move from the center, the less likely this kind of resource is to exist. And sometimes it's done on a volunteer or community basis, with women just organizing to do this. So that's a positive kind of thing. When one gets to trial, it really is all about the evidence. I mean, not to say that we should focus only on the evidence. It's a holistic approach to a battered woman or a sexually violated woman, but it is about the evidence. And even if, my experience has been that even if a woman doesn't immediately go to the hospital, not waiting months and months, but DNA evidence, we're relying quite heavily on DNA evidence to try to identify the perpetrator. So DNA evidence is very subtle and doesn't disappear as quickly as other forensic evidence does. But whether it's the clinical evidence, which is the explanation of the circumstances and the victim's word against the perpetrator's word, or whether it's about the medical evidence, it really turns on the evidence. We have a jury system where not a single judge, but literally almost always a jury hears the case if it does go forward, and that's a jury of one's peers. It's regular citizens who are selected to sit as a panel and hear the case, and the proof is proof beyond a reasonable doubt. So when you're trying a case, the challenge is to figure out, what case is strong enough to go forward. And unfortunately, a lot of cases do fall by the wayside. We have the other support systems. But as a lawyer, this may sound, it doesn't just sound, it really is necessarily hard-nosed. As a lawyer, I don't want to take forward a weak case, because it's devastating for the victim. It encourages the perpetrator. It encourages the perpetrator's circle. It's a message to the police that these cases take resources and don't result in convictions. And it's a message to the greater community and all of those people who are already biased against women and suspicious of rape circumstances as, a valid, something that really happened. So, taking a few strong cases unfortunately, is kind of the how to get the highest leverage. And then also to the whole community, lawyers and everyone who works in this area. Everybody's been saying it all day, you know, that the legal as well as the personal are all political. Everything is political. And so when the conviction comes, leveraging, which means just getting the most out of that conviction by publicizing it to the support community, by getting media attention for it, by learning lessons from it, what worked, what didn't, but really putting out that positive message and getting a lot of publicity and media attention as well as news out to the community that here's a conviction, here's a conviction, here's a conviction, and hopefully using those convictions we got to improve the whole cycle of not just the legal but the social and cultural realm. Again, it sounds hard-nosed and it sounds kind of cynical to, you know, call up the media and get press for the convictions, but I truly believe that that's very important too, because we can't take all the cases. Look, you have tens of thousands, you all know the statistic, I just know generally. You have tens of thousands of rape cases in the pipeline, you know, stuck there, waiting prosecution. We just, even if every case was strong, how would you ever, you know, move those things through the pipeline? So we need to get the most we can from the successful cases. And then at the judiciary level, pressing for tough sentences. The jury decides whether or not there is the crime has been committed, but then it's up to the judge to do the sentencing, and really, in our system, pressing for a very tough sentence and making that part of the, you know, the message, I guess, as well as the individual victory. So those are just some, again, just speaking narrowly as a lawyer, which is probably my highest and best use to you. Those are some of our experiences at home. But, you know, no matter how much experience you have, no matter how long you've been at it, you know, the cases still keep coming. That's the discouraging word. But the encouraging word is that from when I began working in domestic violence cases about 30 years ago, and we in our state started the first domestic violence shelter, we have seen a great improvement in the compulsion of the police to take these cases seriously, not to forget parts of the protocol so that you can't go forward with the case, how to take evidence, how to build a support system, how to bring in people to support